and the different perspectives. Okay, the recording has started now. So we come to the discussion for which today's class has been scheduled. And it's on a very important topic of law. Whenever rather we schedule a discussion on any particular legal philosophy or on any particular legal doctrination, perhaps the most important point, perhaps the reference point for beginning the discussion is Constitution. The course has been structured in such a way that there is not a particular focus on any one constitution of a country or a state. It is rather a cumulative study of an aggregate of philosophies that culminate in creating this body of constitution and the study of constitution. Let's take it from a very ground root perspective, from a very simple and a basic perspective, which is defining the constitution. And secondly, applying the constitution. So today we have so many of you present here in the class, and whenever we are, okay, there are some people in the waiting room. I'm just admitting them. Yes. So beginning with the discussion, that today we have so many of you a part of this particular discussion or seminar or the lecture. Everyone had to abide by a certain set of rules. There was a mail that was circulated. The mail had a brochure. Interested participants had to sign up for the same, then download the application of Zoom and sign up for the meeting. Even the person in charge of delivering the lecture today was bound by certain rules. And the people on the other side of the table today who are taking the points from the lecture are also bound by the same set of rules. So what we find, even in this online gamut, even in this domain, in this Zoom meeting paradigm, is that we find a distinct classification of legal rules and regulations. We even find the way the entire process is being managed with the help of certain rules which are inalienable, first of all, which are obligatory, have to follow, and which define this meeting today. These are the rules based on which we functions. So these are the rules which constitute us. And from this particular word of constituting develops the noun constitution. Okay. This is the ground pretense for our study today. Now, going by the lecture notes, we have been fortunate enough that Charles sir has provided you all with a wonderful module on what will be covered in the discussion today. A wonderful module has been drafted and it has been presented. So in this case, I would like to emphasize firstly on defining a constitution. Class, let's have the discussion first. You guys understand what I am trying to teach. You guys understand the concepts. Towards the end, last 10 to 15 minutes, I'll tally it with the pages. Okay. As I am delivering, I'll just mention the page numbers. Towards the end of the lecture, I'll tally it so that when you read and prepare, you have the page numbers with you. We start with defining constitution. That if you refer to the notes, it's from page 8. The very basic idea of constitution is that it presupposes a state. Now, what is this presupposition, or what is this particular assumption of a state? I, as an individual, cannot have a constitution of my own. I cannot come here and present a book or a written document or something and call it my constitution, or arbitrarily declare it to be my constitution. Neither can a small society or a small non-governmental organization, NGO, or a small trust come up today and randomly declare that there is a constitution. Yes, they can have a set of rules, a set of regulations, they can have a brochure, but they cannot have a constitution. When we are talking about constitution, it invariably gets linked with a state. There has to be a geopolitical entity that is identified by the members of that entity and by the international sphere as well. If it's a country, not only will its internal citizens be its members, identifying the same, its neighbors and other states, other actors in the international theater need to identify that country as an existing entity. So the entity of a state depends on two factors. Firstly, its identity. Secondly, the way it's identified. What is its identity? That its people identify itself to be a state, that others identify itself to be a state. And how does it identify itself? With the help of constitution. In a very layman terminology, the way people are assigned with ID cards, with symbols, with marks, with distinctive marks that identify themselves, constitution is quite the same way a birthmark of a state. So any discussion on constitution is incomplete without discussion on statehood. But today, for the purpose of our constitutional law lecture, the statehood will be given secondary emphasis. The more emphasis will be supplied on constitution as a document. Now, what is a document? Is it always written? Is it always defined? Is it always a bulky, exhaustive note that that is so stereotypically that is so stereotypically visualized of a constitution? No. Sorry to break your notions. England, or rather United Kingdom, has an unwritten, oral, or a verbal constitution. On the other hand, the country where I belong, or my origin, India, it has the lengthiest constitution in the world. It is a written document. So it differs. American Declaration of Independence was also written, from where the constitution originated. So this discussion leads us to one point. What is it? That constitution is a very important document of a state. It presupposes a state. It defines and gives identity to a state. Its people identify with it. And fifthly, it has no particular definition of its own. In countries where the constitution has dominant legal effect, there are often high courts that apply and interpret the text of constitution. In this era, or rather whenever we are talking about constitution, we have to understand that it cannot be a dead document, because there is a distinction from laws and legislative enactments of a country and its constitution. Any legislative document, any legislative enactment is always subordinate to the constitution, because it is the constitution which empowers the legal process making. What if a country starts making a law while it's not a country at all? Will that law be valid? Not at all. When will the law be valid? Only when it has the sanction of a statehood, only when it has the sanction of a constitution. So when we are asked to distinguish between constitution and a statute, we have to understand, while statute is a legislative product of a state, constitution is the defining identity of the state. This thing has to be identified, and this thing has to be okay. So this thing has to be identified, and this thing has to be classified properly. Okay. Now next, let's come to the discussion on different kinds of constitution. It can be written, constitution can be oral, as was the case in United Kingdom, just now I mentioned. When it's an oral document, what is the most, what is what is the incongruity which is faced is that it can be easily amended. On the other hand, it can be difficult at times to refer to it. But when it's a written document, it is always easy to refer to it, difficult to amend it. It has to be again kept in mind that when amending the Constitution, it cannot become such, when amending the Constitution, it cannot become such that the entire thing or the entire spirit of it loses. Amendment has to be such that it copes up or that it gets along with the test of time, but it cannot be such that the entire constitution gets changed or toppled. Why? Because as I always mentioned, or as I am keeping it to be the most important note of the class, is that it is the defining identity of the country or the state. It is the most important identity. Yes, is anyone there wanting to speak something? Yes, Justice Osman Mukhtar. Is there any doubt? Okay, maybe there was some net issue. You can always post your questions in the chat box, or you guys can unmute at any time, stop me, and present your questions, please. Okay, let's continue. So, as I was discussing on the different ways in which amendments, changes to a constitution can be made. Now, why this discussion is done? Now let's come to the making of written constitutions. Why did suddenly this practice of writing, drafting constitution come to the fore? Or rather, what was the need? What was the importance of such kind of constitutions? What was the need of making these constitutions? Or as such, why were they made? This was solely because when a state is in its nascent stage, you need something that will define it in the international scenario. I cannot start a state of my own and start claiming that I am the proprietor of a state. I'm the maker of the state. This is my state. It's not an arbitrary process. A state is bound by individuals who are identifying with it. So how will the international scenario, how will the international regime realize that a new state has come into existence? Let's delve deep into the pages of history. The word constitution was identified in a single document in the late 18th century, primarily as a result of American and French revolutions. These two revolutions are very important when we study constitution. Why? Because French Revolution was for the first time in our medieval European history in the theater of world politics. It was the first time when liberty, fraternity, equality, lofty liberal ideals came to the fore. Lofty liberal ideals were recognized by one country. France itself was fighting a civil war of its own. French Revolution was in itself a civil war inside the country. Now, when a particular group gains the dominance and asserts itself as the true rulers of a country, how will they propagate their ideals? How will they establish the fruit of their labor? How will they materialize their thought process? That is by drafting a document that defines their creation. If a state is created, then a distinct legal document should define the way it is ought to be functioned, the way and how it is created. Okay? That is when constitution assumes its fundamental importance. That is when we find the need of having a constitution. In France, the same need was realized when the lofty ideals had to be embarked on a document that would define the country. And in case of American Revolution, the same was needed to give effect to the ideals which inspired the revolution. As it is very rightly said, Constitution is the predecessor of the government, and the government is nothing more than a creature of the Constitution. So we can recap from the discussion which we had for the last 20-25 minutes is that, first of all, Constitution is not inseparable from government. Neither is government more powerful than the Constitution, because it is the Constitution, it is that legal mount, it is that legal altar on which government resides. Government draws its pool of power. If there is a government, and if it legislates, if it executes, if there is a judiciary, if there is a court that interprets, everything gets inseparably linked to one point, and that is Constitution. Okay. Now, constitutional enactment usually follows a political event. This thing I've already discussed, be it a revolution, be it a civil war, be it state integration, be it formulation of a new state. And this entire process is known as constitutionalization. What is constitutionalization? You can make a small note. Constitutionalization is the process of a state identifying itself as a distinct geopolitical entity in the regime of international affairs and enabling its citizens or residents to identify with its abstract concept, a sense of belonging to the creature it just created. Now, Constitution is a document that gives that identity, both in the international theater, in the international domain, and in the national citizenship paradigm.
I'm sorry, sir. Please, can you go
Yes.
over what constitutionalization means again, sir?
Yes, sure. Constitutionalization, you guys can take a note of it. It's a very important concept. Constitutionalization entails the process in which a particular set of ideals, attributes, philosophies, concepts enables defining of a state, as a distinct geopolitical entity in the international sphere, and enables its citizens or residents to identify with a sense of belonging to the creature it just created. Let us break this thing down. This was a formal technical definition. Now, breaking it down, we have certain elements. What is the first element? That is constitution and constitutionalization. While constitution is the document, constitutionalization is the process. The process of what? The document giving an identity to an entity. And what is this entity? It is the state. Because we have started the discussion that whenever there is a discussion on constitution, what do we presuppose? What is the supposition or assumption? Existence of a state. And hence, post occurrence of any event like that of revolution, civil war, independence, all this. In case of India, it was independence, 1947. In case of many African colonies, it was independence. Independence from British. Independence from colonial legacies of British. When this particular event takes place, the newly born states, the nascent states, need an identity. And when a particular document gives a nascent state its identity of existence, that is when we call it constitutionalization. Constitutionalization ended in Eastern and Central Europe in 1990s, when the revolution on the socialist regime led to creation of new structures that embraced liberal and democratic values after the collapse of Commission. Okay. This particular note has been incorporated because we know in 1990s there was the collapse of communist regime in USSR. Mikhail Gorbachev led the collapse of USSR, and Soviet Republic of Russia came into existence. That was a very important landmark because Latvia, Lithuania, and many other countries were born during that time. Just before that, we had third world countries of India, different countries in Africa. They were gaining independence, and everything needed an identifying element. What was it? The same was Constitution. Okay. Legal consequences of unwritten Constitution. As I have already said, which country had unwritten Constitution was mentioned by me. Can anyone answer? Is there anyone in the class? Name the country which has an unwritten Constitution. I mentioned.
United Kingdom, sir.
Yes, very good. United Kingdom has an unwritten Constitution. So in the very beginning of my discussion, I mentioned a point that in case of unwritten Constitution, it's easy to push forward with an amendment. But what is the problem? Problem is a reference, because it's verbatim. It's a commune-based transmission, whereas the ideals of a constitution keep transmitting from one generation to another. It's sort of a legacy. It's sort of a verbatim legacy that gets passed on. You don't have a very tangible source to hold it. But at the same time, it needs quite some, what can I say, quite some expertise on the same. There is no legal constitution in UK. The gaps that emerge are filled with the legislative dominance of parliament and the doctrine of rule of law. We'll come to every single topic in details. Dominance of parliament, rule of law, everything. As of now, just to proceed with the discussion, you guys should keep it a point that UK has unwritten constitution, because in different competitive exams also, this sort of questions are asked. Now, moving on. Constitution, cabinet, drafting, parliament. Constitution, we know. What is cabinet? Cabinet is one legal authority that is either created by the constitution or that can even presuppose a constitution. For example, in case of India, while India was still a colony of the British, there was a cabinet mission plan. There was a particular legislative indoctrination whereby eminent people, practitioners of law, came together, joined hands, and started the process of drafting of constitution. And from that cabinet came the constitution. And what is another cabinet? One that is created by a constitution, that can be a law-making body and exclusive legislative body created by the constitution. What kind of a body? Legislative body, because a cabinet is concerned with drafting the law. Here we come to the third point, drafting. What is drafting? Every lawyer in every phase and stage of his or her career comes across this particular term, drafting. Drafting is nothing but writing. Writing in a technically motivated jargon to present ideas peculiar or stereotypical to a particular field. A technically stipulated jargon. Drafting is a technically stipulated jargon, an exercise undertaken to draft ideas stereotypical of a particular field. For example, in law, there is legislative drafting, legal drafting, drafting of claims, drafting of bail petitions, drafting of writ petitions, drafting of whatnot. And in case of cabinet, it is legislative policy drafting or rule making. In layman terminology, it's known as rule making. Okay. Therefore, a lack of written constitution means that UK government relies on legal rules and guarantees based on political democratic principles. Now, be it written or not written, we feel the need to change the constitution. As I have already stated in the very beginning of our discussion, there is a glaring need that the constitution should keep up with the challenges of the time. And these challenges of the time are very important because suppose a country gains independence at a particular point of time and its constitution is drafted then and there because that is how its identity is created. What about like 50 to 60 years have passed? What after? The needs of time have changed. Contemporary challenges emerge. For example, 1950s saw the challenge of rising individuation of states, rising freedom. 1960s saw glaring terrorism. 1970s saw environmental litigation. 1980s saw technical evolution. 1990s saw further technical evolution. And today we are seeing artificial intelligence revolution. Things are changing very fast. The biggest challenge from last year is the viral pandemic, vaccines, protection. Everything is a challenge that the constitution can meet because the constitution is always based on political and democratic principles. Now, this democracy also functions differently in different countries. You have voting, you have eligible voters list. I would say constitution is driven by only one principle. That is the principle of political cooperation of the ruler and the ruled. Even today we are ruled. Maybe we are not a colony anymore. Maybe we have gained independence, republic, democracy, what not. But still, there is a ruler or an administrator, and there is a distinct segment of people who are ruled, who are subjugated to that administrator. There is majority and minority. There is majoritarian thought process and minority protection. But everything stems its legal autonomy, stems its legal sanctions from one document, that is constitution. Let's come to the next discussion, constitutionalism. The last discussion was constitutionalization and application of constitution. Now we come to constitutionalism. Norwegian political scientists, we have come to page number 12 now. Constitutionalism, page number 12. Norwegian political scientists state that constitutionalism is a mere political doctrine that argues that political authority should be tied to a system that limits the exercise of power. What did I mention? I mentioned that constitution is, first of all, the identity of the state. Second of all, shapes the political relation between the governed and the governing body. Same view has been taken. But Western liberalism requires a written constitution, a democratic parliament culture, judicial system. Okay. Now, constitutionalism can be defined in various words. It can be the philosophy of the constitution. It can be the, it can be what else? It can be the way a constitution is interpreted. It can be the basic principles of the constitution, the basic structure, something called basic structure. Guys, you can make a note of this. Basic structure is the basic nature of a constitution. How can we identify basic structure of a constitution? The core principles of a constitution that are inalienable, obligatory, cannot be done away with, cannot be changed. That is constitutionalism. And while constitution is a stagnant document, either drafted, written, or oral, with a set of principles. Constitutionalism is never stable. It is the most dynamic aspect of constitution. That is, it changes every time a new constitutional challenge comes up. What is a constitutional challenge? A crisis or a particular legal doctrine, a particular challenge, circumstantial challenge that poses a threat to the country and its stability, that needs interpretation of constitution and its principles by the highest courts of the land to solve the same. That is a constitutional challenge or a constitutional crisis. A country which has recently suffered a constitutional crisis and the country collapsed, Afghanistan, due to the military takeover. Last year, this year, 2021 February, Myanmar, military junta takeover. Liberal countries being taken over by radical militants. That's a constitutional crisis. Because at that point, the entire system of governance collapses. You have a very neat description on constitutional law and administrative law. I'll not go through that because I've already discussed that. The entire governing system is administration, and that administration is guided by constitution. Okay, I'm directly coming to constitutional law and public international law. What was my first point when I started discussing about states? That was, a state has to be recognized not just by the people who reside, citizens who reside, by a sense of belonging, but also by other states. Other states have to recognize that it's a state. Or else, how can the state be recognized as a state? It has to gain a recognition in the international sphere. Now, public international law is that branch of international law which governs the external relations between one state and other. Yes, international organizations have established new forms of cooperation between nations and established a code of conduct. Okay. Now, when we are talking about constitution and public international law, there are two very important aspects. First of all, different countries can cooperate on the basis of what they think and what they believe. Countries are inanimate, non-living, abstract concepts. How can two abstract concepts suddenly start communication with one another? That's just impossible. But what can communicate with one another? What can cooperate with one another? The essential qualities of a country, the way a country is defined, and that is constitution. So that's how public international law and constitution are related. Clear? We move on to sources and nature of constitution. These things have been discussed already. I've discussed a lot on nature of constitution. I'll directly come to sources. Sources can be, first of all, as I said, a cabinet, a particular committee that drafts a constitution, a legislation, a law-making body like parliament, a king in a non-republican setup, a monarch, and the constitutional law process is further enriched with the help of case laws. Why case laws? It's very common of a common law country, ironical of me to say that in this way, common of a common law country, that when a common law country judicial system functions, it poses enormous reliance on statehood, on cases. A case is a circumstantial question in dispute. That particular dispute is contemporary. With the help of such contemporary disputes, challenges to constitution come. And overcoming each challenge is a principal point of interpretation of constitution that ultimately adds to the body of constitution itself. And lastly is customs. A land always is governed by a law, lex fori, law of the land. Before the laws being formalized, there were unwritten systems of rules, unwritten systems of observances. These were called customs. They are unique, they are continuous in their application, they are antiquity, sometimes 100 years or more. They cannot be traceable right from which point or at what year exactly, which year they began. It's just that they have been in existence for a pretty long period of time. And that's how customs are very important in defining the law of the land. And the law of the land, lex fori, is once again connected to the state. And what is connected with the state? Constitution. Constitutional action followed by precedent, ministers, lawmakers, law or judicial listing. Okay. So now this thing is done. Conventional rules of the Constitution, it's a general law. You can all read through these conventional rules and all of this. I will directly start with governance, constitution, unconstitutional, and constitutional challenges. What is governance? Governance is the way in which a code of conduct is relied upon and followed by officers and administrative in charge people, rather people who are administrative in charges. They are the way, rather the way they are functioning, that is called as governance. Governance is usually carried on by a definite systematic body called government. And who comprises government? Once again, it is constitutionally defined as who would be the leader of the government. It can be prime minister. It can be president. President is the leader of government in which country? United States of America. Prime minister is the leader of government of which country? United Kingdom. This is a very clear distinction between common law countries, civil law countries. But let's not go deep into that. Let's rather stick to our topic, and that is governance. When I'm talking about governance, it is a systematic application, an execution of the process of administration following a rule of conduct that has been envisaged or doctrinated in constitution. Government is the governance, is the process by which particular officials entrusted by the constitution following a defined code of conduct administratively adjudicate in the process of managing a country known as its countrymen in the process of governance. Okay, so this is governance. And how does constitution play a role in the process? Constitution is once again that document which defines the state. So while defining the state, it has to define the nature of the state. For example, if it's democratic, if it's a democracy, for example, United Kingdom, United States of America, India, what happens in a democracy? People get the right to vote. We can choose our own leaders. And that right is inalienably the way in which governance is decided. So once again, governance is the process, government is the body, and constitution is that document again, which is defining both. While discussing on good government, there is a code of conduct that cannot be breached. And when the code of conduct gets breached, it is bad governance. It is bad in the eyes of law. What is it? It is bad in the eyes of law. And this particular bad in the eyes of law is given a technical jargon of unconstitutional, which is, you can note it down, behavior in violation of the unwritten but commonly acknowledged ideals of the Constitution / an explicit conduct which breaches the constitutional procedure. For example, threats to destabilize a state, action against state. For example, laws that are discriminatory, discrimination on the basis of race, color, gender, sex, in a country, in a constitution that pleads equality. Okay. Now, in order to understand what is unconstitutional, it has to be understood first that constitution has to be interpreted and constitution has to be amended. Why? Before amendment, let's start about interpretation. If you do not interpret the constitution, if you do not know what is there in the constitution, then you cannot understand what is there meant for you, meant for the state. In case of interpreting the constitution, a very liberal approach. What is liberal? There is a domain of study which is known as interpretation of statutes. Now that is not my subject here. I am not given that subject this time. In my subject, I will deal with only interpretation of your constitution. In order to interpret your constitution, always remember liberal approach has to be adopted. Liberal or golden rule. Please write it down, students. Liberal or golden rule of interpretation, whereby intention of legislature with a rational approach, intention of legislature coupled with a rational approach has to be used to interpret the doctrinated philosophies in a constitution. Okay. And that is how your interpretation of constitution takes place. Now, after interpreting a constitution, you understand that there are mechanisms. One is union, center. One is states, federal. It is either unitary, where the entire country is administrated with the help of one strong center, or it's federal, like United States. There are small states. Every state has its own definite power. That is federal. When you divide and when you unite it under one, it's unitary. Okay. There are constitutions which are quasi-federal. That means semi-federal, semi-federal, half, not full. So these are all the ways in which we can interpret a constitution. And coming to amendments, I've already discussed that while amendments is to be done, now you can write this. After this entire discussion, you can write this in a very technical jargon. You can write that amendment has to be done with the help of constitutionalism. Amendment can be moved to change a particular aspect of the constitution without compromising with the basic structure of the constitution or changing the constitution as a whole. It is a process carried out with the help of, administrative officials, especially entrusted with the process. Your course covers till this much. We are left with a discussion on human rights. Before discussion on human rights, let's talk about three most important aspects in the study of constitutional law. One is rule of law, one is equality before law, third is the separation of powers, the Westminster model. Rule of law, A.V. Dicey, invariably. Remember, A.V. Dicey, the biggest scholar of his time. What is rule of law? You guys must have wondered before discussion of human rights, why did I suddenly start off with rule of law? Because human rights and rule of law are very related. If a particular person is administering the law or making the law, is he above the law? Can he go as he likes? Can he do anything? Or will the law apply on him too? Yes, even the lawmaker is beneath the law, because law is the supreme. What is supreme? Only and only law. Hence, rule of law. And equality before law is that it's a legal point of view. No one is liable for prosecution except in a case of a clear violation of the law normally enacted in the ordinary courts of the country. Normal, ordinary, very ambiguous words. What is most certain? Equal law for equal people. Equal application of law for equal people. And everyone is equal before the law. So what is this? This is a constitutional application of philosophy or application of constitutional philosophy. Stems from constitutionalism. Because what is constitutionalism? The doctrines and philosophies which define the body of constitution. And lastly, separation of powers. It's, when we are talking about a law, someone has to make it. Legislature. Someone has to execute it. Executive. And in case of a dispute, someone has to decide who is wrong and who is right. What's that? Judiciary. In your country, you can identify legislative as the legislative assembly, the persons who make the law, prime minister. What's executive? Persons who execute. Police, the law barriers, right? What's judiciary class? It's the courts, where you go to take refuge in order to adjudicate a particular dispute. We move on to the last part of the discussion of the entire module, that's human rights. I want you all to talk about human rights. But before that, IHL I am discussing today. UDHR, almost everyone knows, Universal Declaration of Human Rights. That's the most translated document ever on this earth. Everyone knows that. Eleanor Roosevelt, after First World War, gruesome loss of lives. And okay, let's go into the technical details. A case called Entrick versus Carrington is a constitutional principle derived from common law. John Entrick's house was searched by Sheriff Carrington. Carrington argued that the arrest warrant from the government minister Earl of Halifax was a valid authority, even without statutory or court order. A court led by Sir Camden said the main purpose of people's rights in society was to keep their property safe. In all cases, this right has not been deprived or diminished by public rights for the benefit of English law as a whole. Sacred and invaluable, invasion of private property is a violation, no matter how small it may be. Okay. So why is this particular case very important? Entrick versus Carrington, because arbitrary search was carried out in a house, in a personal property that was protected. Now, class, let's forget about human rights and all. Identify it with the help of Constitution. What comes first? Equality before law. The sheriff and the person, the resident of the house, both are equal in the eyes of law. Now, what's the sheriff? Is he legislature or is he executive? Answer, anyone? Is the sheriff a legislature or executive?
An executive, sir.
Exactly. Why is it executive? Because he is carrying on the onus, the burden of executing the drafted laws. The law has been drafted, but he is executing. And hence, even the executive is not above the law. We come back to the discussion of rule of law. That's why I combined this topic with human rights, guys. Okay. Rule of law is invariably the beginning point of any discussion for human rights. Because why is there a human right? Because everyone is equal. No one can just deprive you of your dignity, of your life. No one can discriminate. And hence, IHL is the body of law, international human rights, where there are different conventions, charters. These things are basic, very basic. Okay, these things you have to study. It's very basic. Guys, can we get slides on these things? There is something which our council Emmanuel has said. What is it? Just let me see. Please, sir, can we get slides on these things? Okay. Council Emmanuel, the entire thing, something, my additions, I have specifically been very slow in telling my renditions, my additions. So this thing is on record. You can always refer to this, Council Emmanuel. And the other things, other doctrinal things, has been wonderfully prepared by Sir Charles, and it will be shared to you. It was shared in the mail itself. The mail, the invite which you got, please search for the attachment. It's there. It's wonderfully compiled by Sir Charles. But my renditions, my additions, I've been very slow. Anytime, open up this recording. It's a 1 hour class. You can find everything here. But still, we'll keep one more class of 30 minutes where you guys will request me what are the notes you need. I'll give you well drafted notes on that too. Okay. So concluding our discussion with human rights, UDHR, it's very sad that a document was needed to identify human rights. It's very sad because the human right is not born or it cannot be reminded to someone. It is very intrinsic to my body, to my existence, to my birth. We find feticide, killing of the fetus. We find terrorism. We find racial violence. We find gendered violence. Everything is a deprivation of human rights. Today, just as I said, 2 states had collapsed in 2021. We had seen Myanmar, we had seen Afghanistan, we have seen North Korea. We are seeing North Korea. Recently, in North Korea, people have been banned from smiling and laughing for 11 days. It's like a national mourning, but it's an imposition on them. Even that's a violation of human rights. We have human rights discussions in UN, and I have been working as an activist of human rights in my country. I've worked with Council Nathan. I've worked with Masterclass on human rights. I've worked with litigants' human rights. And what I find is that it's very sad that you have to remind people that they have rights. And at the same time, when we try to compromise on human rights, that's when statehood collapses. Okay. So it's exactly 1 hour. I would not stretch it any further for the sake of the recording and all. The recording can be stopped now. And I would like to